Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need. Welcome to episode 9 of You Can't Say That in Court. Today we have a guest who have some excellent firsthand experience with how family law legislation has evolved over time. We have Natalie with us today, who is our colleague at RISE and is here to help us get into how we arrived at the Family Law Act right now, which is the legislation that stands today, and the definition that it has adopted with regards to family violence. Natalie will talk about what has been working and what might not be working so well. And I'm just going to pass it over to you, Natalie, to introduce yourself.
Thank you, Vicky, and hi, Stephanie. It's absolutely wonderful to be here. So thank you for inviting me. I'm Natalie Longe. By brief introduction, I'm a lawyer working at RISE. The team I work with is the Virtual Legal Clinic. We serve women and gender diverse clients outside of the Lower Mainland and assist them with their family law issues. And to give you a little bit of context for why I have been asked to talk about the evolution of family law is because I was called to the BC Bar in 1998, which is a very long time ago. And I had to laugh. A while back, we were going through some boxes in the garage, and I opened one from my previous time in practice, and there was a dictaphone in there, and our children had no idea what it was, how it works, why anyone would need to use that. So that's how long I've been practicing for. And I do just want to add that I have also worked as a family law advocate. And I would like to talk a little bit about that today later, just because that also gave me a different perspective on the issues that we're talking about today. So thank you for inviting me.
Oh, we're so happy that you're here. It's really great. And you know what? Experience is power. And I don't think... we are very similar ages. So I think this is really great that you're dating yourself.
So we're not old.
Yes, exactly. So on that note, can you start us off with some of your observations about the fact that, yes, finally, the legislation or the law in BC has a pretty robust definition of family violence, but that there are some implications to that?
Yeah, definitely. So just to take you back, the Family Relations Act, that's the old legislation that existed before the Family Law Act, which we work with today in British Columbia. So I'll call that the FRA. The FRA came into force in 1972. So that was an old piece of legislation. It was hanging around for a long time. And it needed to be modernized. And some work started on that, I think, in about 2006, and finally came into force and effect in 2013 with what we're now calling the FLA, or the Family Law Act. So that essentially superseded the FRA and replaced it. And in the Family Law Act, in the FLA, the legislators identified family violence, and that hadn't been specifically identified in the FRA. It is tragically, obviously not a new concept, certainly not in family law. It's always been around. And when I was called to the bar and when people were called to the bar 50 years before that and 50 years before that, there was family violence. But in the FLA in 2013, we had that encapsulated with a legal definition for the first time. And then there were a couple of other additional sections, primarily relating to children and the best interest of the child, that also relied on some of that language. And whether or not it's been a positive development, I think the legal answer is always it depends. And it really does depend. It depends on, who you are in the courtroom. It depends on your background, your education. It probably also depends on your knowledge and experience of the family violence legal system and how that plays out even just in communities. So I wanted to talk a little bit today about, family violence doesn't just happen in courtroom litigation. It happens in communities. And does the legislation reach more people in a community setting than the old one did? I think the Family Law Act has done a lot for bringing the concept of family violence into communities and helping us identify it, helping everybody who's working with survivors identify it. So I think in that sense, there's been a lot of progress. And I think we'll spend some more time today talking about some of the problems too that have arisen with legal definitions that are then being argued to varying degrees of success and effect in courtroom settings.
I have a question. I think this is the pre-question to my actual substantive question, which is under the FRA, when you as a lawyer representing a client who may experience family violence, how did you navigate that? Because you can't just go to court and say, Your Honor, Judge, my client is experiencing family violence as defined in the legislation. Right, because there was no definition under the FRA. So what did you do in pre-2013?
Yeah, it's an excellent question, Vicky, because I was thinking back to how did we bring these arguments when we didn't have these sort of quite tidy rubrics and outlines to follow. And, even gathering the evidence, we have the advantage now of looking at the legislation and encouraging our clients to start thinking about their timelines and their experiences in the context of, we're going to be arguing this in court. And so let's break it down neatly. I'm going to suggest it was less tidy in that sense, but also not all that different, because these concepts, even though we didn't have the words necessarily and the definitions, the actions that our clients were suffering were the same. That really hasn't changed. So I think we probably filtered out more forms of violence than we do today. And I say that reluctantly and with some sadness in recognizing that it is easier to talk about forms of violence that have been recognized in legislation. And it was more difficult to encourage clients to bring forward claims that, it was like 2 hurdles instead of 1. Not only did we have to have the conversation with the survivor, but then we would also have to convince the court. And truly, I think it's easier to have 1 hurdle. And so in that sense, having the legal definition and having the legislation provide the rubric has made some things easier.
And I guess this is my substantive question is, Miss Stephanie, maybe you have the same question, which is what is harder or what is difficult? Because you say some things are easier, but what's the other side that you're not
other
seeing?
Side, and I don't think, when this first, when we first had this legislation presented in 2013, I think there was a lot of hope that it was very progressive, very modern, and we were going to, as lawyers, that's really the perspective I can speak to it from, it felt like we were being handed a tool. And a very useful one. And I use the analogy of a shovel because I think previously you sometimes felt like you were standing in the courtroom with a you've got some heavy digging to do, and you've got a spoon, or maybe on a really good day, you've got a bowl that you can work with to kind of shovel this heavy load of information. And then we were handed a shovel to make the digging easier. And it felt like a tool that I wouldn't want to part with. Like, that was a very useful and practical tool. Then what started happening, and I think everybody's experience of this could be different, but I certainly have talked to other lawyers who also had this experience, is we were also told in this rubric of family violence definition, there are lots of different forms of family violence. Some are more obvious than others. For some, bringing the evidence is more of a concrete, hard evidence. Like, I'll use the example of police records or hospital records to substantiate abuse. But then the legislation also encapsulates very insidious forms of abuse, like, for example, coercive control, which are very small actions, small forms of abuse, but over long periods of time, much more difficult to prove. But we had the same shovel in our hand. We have the same shovel, I should say. This is ongoing for the more obvious, prevalent types, and for the more insidious, discrete types of abuse. And I think the feeling is that sometimes you're standing in that courtroom and you're waving the shovel around, and people are tuning out. And it's so unfortunate, because you're asking them to listen more closely, to lean in and tune in more effectively, and taking the court through the legislation very precisely. And in some instances, the opposite was happening, is that judges are leaning out and saying, I've heard so much of this. I've heard, I would say predominantly family law matters that make it to court have family violence attached to them. That's not an unusual situation. So we're making same or similar arguments over and over again. We really have just this one legislative tool. And I think there's some eye rolling happening about, is this an effective tool? And I think layered with that, we now have this sort of realization that the myth and stereotype that women are not credible, and that they will say things in court to attempt to gain an advantage in litigation, that has become bizarrely intertwined with family violence. And it's really difficult to untangle, and very difficult to identify even, and then untangle with evidence. Those are hard steps.
Yeah. I think with the eye rolling too, it's almost like, oh, not this again. Like, a lot of lawyers have like kind of shared with me, and like one of my mentors have shared with me, it's like, she says, this is like the worst thing that could have done was have a definition of family violence, because judges hear it all the time now. And there's this kind of attitude like, oh, not again, or how can there be this much quote unquote family violence when before it wasn't brought up as much. But the idea, it's not like suddenly with the creation of a legislation, more people are experiencing family violence. Like you said, it happened before. Now we just have the tool or the shovel to name what it is. But it doesn't mean like suddenly there's more experiences of violence than prior years. So yeah.
Yeah, exactly. And I think, we have the tools to name it, but the survivor, most importantly, has also been given this tool to name it. And I think really some of the prevalence of family violence that we're seeing in our clients, it's always been there, but I don't even think people could name it for themselves. And I think coercive control to me is an excellent example of that, because before we had that language, what were we calling it? Like, we didn't really have a very established way of talking about that. People could tell you, a small story of this thing that happened today that, well, and I think you've used the example in the podcast in previous episodes of, somebody withholding a wallet from somebody else, which, depending on context, is that a controlling abusive behavior? Is it? But of course, context will establish patterns over time, but you need the language, I think, for people to be able to identify really what they've experienced, and then they can talk about it maybe a bit more freely.
Yeah. And I think that's the hard part of showing it to the courts, or like, because it's a pattern and it's a pattern over time, whereas the legal system, as we have discussed before, is very incident based. So just saying this one incident where this person took my wallet and didn't give it back to me, maybe well, yeah, maybe like you were on a trip, it made sense, like for one person to hold all the money or all the cash. But it's like over time, like when they returned back home a few months later, all the what we call now financial abuse can be presented, whereas there's not a lot of time in the courts to present all the things that have happened over several months or several years.
Yeah, it's so true. And then I think the other thing that starts happening is, we have time restrictions on the evidence. We have a limited amount of opportunity in a courtroom setting to make our case. So we're tempted, I think, as lawyers, to choose the items that are easiest to prove, the ones with the biggest impact, those sort of one-off incidences that Vicky is talking about. And that certainly has created this bizarre hierarchy, I think, of family violence, where we're now, people have understood for a long time that physical abuse, physical family violence, that's easily identifiable. Emotional, a little more subtle. But then we get into these issues of financial abuse, coercive control, and those are much harder to prove. And I'm going to frankly say most lawyers shy away from them. And
Yeah.
it's created a really unfortunate pattern of hierarchy, where we'll choose the abuses that are easier to prove, that will get us more traction, that we think you will be believed on. And then we'll leave out the ones that might result in some credibility questions. And so I think some of our clients have said to us, they had counsel who told them not to talk about this in court because they wouldn't be believed. They wouldn't feel like they were being believed, and they actually, it would impact, excuse me, their credibility.
Yeah. And it's quite contradictory because like I've definitely have clients, and I would assume the two of you have supported people in the same situation as well, where they're like, I can take the physical abuse. Like it's not the physical abuse that I'm concerned of. It's like I can't take the emotional or the psychological manipulation. Like that is the stuff that I want to stop. But that's the thing, like as you say, Natalie, is difficult to demonstrate the pattern over time to the court.
Yeah, exactly.
Yeah. I was going to say, I think one of the filtering out of some of these harder to prove, quote unquote, forms of violence is one of the dark sides of having a robust definition like that. But then I know you've spoken before, Natalie, about another one where before there was a definition, there was this really long and detailed process required to bring evidence into the courtroom. Judges expected that level of explanation and evidence to be presented. And now by having a definition that can be pointed to, there's actually a dark side to that as well, because there's a baked in assumption that everyone understands all the nuances of those different types of abuse, which is not necessarily true.
Yeah, it's so true, Stephanie. And I think that the aspect of that is sort of, how do we integrate family violence into this whole legal system? Like, how do we integrate the concept? And really, it's an education piece, I think. And when that legislation first came into effect, I wonder if everybody appreciated just how long the education would take and how difficult it is to accomplish, because it's not, I mean, educating lawyers is one thing. And currently in BC, it's not mandatory for lawyers to have, for family law lawyers to have training in family violence. But that's
Right.
one aspect that maybe, RISE is working on that. Lots of organizations are working on that. Maybe we'll get to that point. And lawyers are not the only players in that system. So we also need judges to be educated in family violence. And I think that's historically been difficult to do on social issues because of the perception of bias. If we're teaching judges, who is teaching them and what is the content is a really important factor. And then, the support workers that are working in the system. And there's lots of people that need learning in the area in order to integrate the utility of using that legislation overall. So it's so interesting to me that it's a time-consuming and slow process. And yet, we were in a rush to get people to understand this. And so you would use the words, assuming if I use the definition, everybody will appreciate what I'm saying. And maybe there was some hope that the fastidiousness of having to prove each of the elements of the abuse would be made more efficient, that we had this sort of more efficient opportunity. And I think what's been established over time is that is not the case. And in fact, the opposite is true. We need more information, more words, more education, not less. And bring those details forward, and for the lawyers, take the time to educate the judge on your hearing, because you cannot make the assumption that there is full understanding. And actually, on that note, I will add that this isn't the first time that we've seen sort of the introduction of language that requires a lot more information attached to it. And I think listeners might appreciate the term parental alienation. When that kind of came on the scene, there was a lot of talk in family law about parental alienation, and there still is. And then we got to the point where, many, many, many family law files had parental alienation claims in them. And lawyers got to the point of assuming that the court knew what we were talking about when we made a parental alienation claim. And we stopped kind of identifying the basis for the claim, the proof that is attached to it. And when that happens, you really erode the efficacy of it. Then, then it's just words. And unfortunately, we can't take shortcuts in that sense.
And I don't think the definition of family violence should be a shortcut, right? It's more of a roadmap to show us what is included in this definition and what evidence lawyers need to bring to prove and demonstrate to the courts what family violence is. It's not a shortcut to just say, my client experienced family violence. This is what the definition is under the Family Law Act, right? There needs to be some form of evidence, whether it's by affidavit or, doing a trial where viva voce evidence is provided, where someone is describing what they've experienced. And then we can say, based on what they've described, it fits the definition.
Exactly. And none, the burdens of proof have not changed. The evidentiary requirements have not changed. So in that sense, the Family Law Act actually didn't change that much, but it, as you say, Vicky, it gave us a roadmap. It gives us a roadmap for the courtroom setting and also for the communities that you're working in. Stephanie, you and I are both really involved in the virtual legal clinic with community partners, working with community partners. And I think the feedback that you've been getting, especially, and I hear it periodically from them, is how helpful it is to start a discussion with a client about abuse when you have this roadmap in front of you. And I think when I was working as an advocate, I truly sometimes saw the light go on with survivors, and it was not unlike that feeling, I think, of watching a movie that addresses the nuances of your life for the first time, or reading about
Mm.
yourself in a book for the first time. And this experience of kind of normalizing, in the sense that obviously the abuse is not normalized, but this is happening, and you are not the only person that this is happening to, and being seen and being heard because it's enshrined. Now it's in the legislation. People have thought about this and written about it and decided it affected enough people that it's real.
Yeah, we have talked about using that definition as an education piece for survivors as well. And although it was written originally, for use in the courts and to provide a framework and a roadmap, like you say, Vicky, it can be really useful to just point to it. It also requires a bit of kind of societal level education because the term family violence is a legal term. That is not like
Mm-hmm.
a commonly understood concept, just generally out in the public kind of thing. And so when you talk about education kind of at all levels, there's also that societal understanding, especially like you said earlier, Natalie, around coercive controlling behavior, because that is a hard concept to grasp sometimes, especially when at like a general societal understanding, it's, oh, he's just stressed at work and this is how he lashes out at home. Things will get better once
Mm-hmm.
or whatever excuse it is, and trying to compartmentalize or justify or dismiss whatever it might be. It's helpful to look at it as, oh, no, this has been going on for 30 years and it's abuse. That's what it's called. Yeah.
Yeah, I think the definition of coercive controlling behavior is really difficult. Like I don't think there is a shared definition, right? Everyone's trying to find ways to define it. But one thing that I always ask when I talk to clients and I ask them, I'm like, do you ever feel like you're walking on eggshells? And they're like, oh
Ah,
yeah. And that's
mm-hmm,
kind of instead of
mm-hmm,
using like I'm not going to ask someone, have you experienced coercive controlling behavior? Because they're
mm-hmm.
like, what? Like, what does that mean? So like the words that we use, like family violence, coercive control, those are quite obscure and like
Yeah.
vague.
Technical
Yeah,
Yeah,
legalese. Yeah,
absolutely. They sound
totally.
like legalese, exactly.
yeah, yeah. But I think the walking on eggshells one is quite common.
Right.
Right. And I think that's such a good, like, bring it into your day to day. Like, what does
Mm-hmm.
this feel like in your daily experience when you're opening a visa bill that's come in the mail? Are where do you do that? When do you do that? Is it okay to do that in a room that your spouse is standing in with you, or do you know that that's going to spark a giant argument that you're not prepared to have? So you're going to do it later in the bathroom when you're on your own, and then
Mm-hmm.
figure out a way to tell him how much money is
Mm-hmm.
owed, that kind of thing is,
Mm-hmm. And even what we call that, because that's safety planning.
yeah,
So even
true.
the
Right.
term safety planning about those things those actions you just identified, Natalie, are also very technical because no one would be like, oh, I'm planning for my safety by opening my visa bill in the bathroom or opening it during a time where he's not there. But that's
Mm-hmm.
essentially what this person is doing.
Yeah,
Yeah.
it's so
I
true. Yeah. Sorry, Stephanie.
No, not at all. I was just going to say I really like how practical it's getting. There's been a really nice arch of like where the legislation came from, where we are at today, and then what kind of practical considerations there are for making it more real and more valuable in using it as a good shovel, a useful shovel to have in court. We're getting near the end of our time. I just wondered if there were any pieces that you didn't have a chance to share with us. I know you have a lot.
I do. I do. I have a lot to say on this topic, obviously. Well, and I guess I would like to add a positive note. I think it's very easy to say, gosh, this thing has become unwieldy and it's difficult, and it is difficult. The the subject matter is difficult, the definitions are hard, bringing evidence is hard. But I think we need to persevere socially, societally, all of us. I think lawyers need to persevere. You know, don't stop using the language. Don't stop relying on the definitions. Judges need to persevere. I mean, this is the work. It's our jobs to do the work. We have survivors that need us to do the work. So I think as frustrating as it might feel at times, there are also indications that it's really working. This work is working. And, you know, we've recently had this wonderful decision from the BC Court of Appeal, KMN, argued by one of our amazing lawyers here at Rise, Vandana Sood, and I know she spoke about it in one of the earlier podcasts, but that is, to me, a big signal from the bench. We're listening. We're understanding myths and stereotypes better. We're willing to go there. We are maybe more ready to close the gap than ever. So I think there are some really positive glimmers, some hope, and I think we should just keep doing the work, insisting on the language, and understanding that it will be hard.
Yeah, no, that's fantastic. And it's always so nice when we can end on a bit of a note of hope. And I think the best part of what you've kind of walked us through today is just being able to look back from where we came from, where we came from, and then recognize we are moving in the right direction. So thank you for all your encouragement and your super great insights. It was so nice to have you here today, Natalie.
Thank you both. I loved it.
So coming up on You Can't Say That in Court, we are airing a pre-recorded discussion about legal intersections with family law. This was originally a 2.5-hour panel discussion with 3 experienced lawyers in criminal law, immigration and child protection, family policing, talking about the overlaps with family law in BC. So we've split the conversation into a 5-part series that we're releasing every 2 weeks throughout the summer. It's really practical and reflective about the issues that survivors face when they have stuff going on in more than one area of law, which is surprisingly often. So I hope you'll listen when we're back in 2 weeks with the first part of that discussion. Until then, take care.
Bye, everyone. See you soon.
See you soon.
See you. Bye.
Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer. We want to acknowledge that this podcast would not be possible without the generous contribution by Women and Gender Equality Canada, Femmes et Égalité des Genres Canada.